All right, hello everyone. This is Professor Smith, and this is a video talking about closing arguments. Now, we've come to basically the end of the semester. There are a lot of things that we've covered during the semester. We talked about jury selection, we talked about opening statements, we've done direct examination, we've done cross, we've gone over objections and the rules of evidence, and now we're talking about closing arguments. Now, the key to an effective closing argument is to make sure that you remember a few things. First and foremost, know your judge. Every judge has a unique way they love for their courtrooms to operate. Before you start any litigation in a judge's courtroom, it's important that you do some intelligence on the judge. Talk to colleagues who've appeared in front of that judge, read the judge's criminal scheduling order, perhaps even make a call to the judge's courtroom clerk or assistant and find out what the judge's rules are with regard to closing. You may find, for example, that the judge sets time limits, that the judge requires you to stand behind a podium when doing the closing, that the judge requires you to give information out concerning any visual aids you intend to use during closing. In short, it's important to know who your judge is because you may come in with a brilliant idea for a closing and then find out that the rules of court don't allow for that. So do your homework and find out about your judge and how she runs the courtroom. Second thing that you want to focus in on, closing arguments, in order to be, I think, truly effective, if the case allows for it, need to tell a story. Stories are the primary ways in which we transmit information. If you think about it, people read books, they watch TV shows, they watch movies, and these are all ways of telling stories, which are really just grand ways that we as human beings transmit information to each other. Don't make your closing argument a stale recitation of the facts and then an application of the law. Save that for oral arguments before a court. Instead, tell a story. Go back and show the jurors how the evidence that was introduced supports the story that you told at the beginning of the case. Compelling stories draw people in, they pay attention to them, and if you can find familiar stories or familiar frameworks and you can apply it to the particular case, well, then you're going to give a much more effective closing. In addition to telling a story, what you want to make sure that you do is that you factor the jury instructions into your closing. Jury instructions should be one of the first things that you look at when thinking about how to put together a case. And how are you going to know that? Well, you know what the claim is that has been brought on behalf of your client or against your client. And if it's a criminal case, obviously you know the charges that you're trying to prove if you're the prosecutor, or the charges that you're trying to defend against if you're the defense attorney. If you take a look at those jury instructions, it's going to be incredibly, incredibly effective in terms of preparing the closing and delivering it. Here's why. When you're able to say during your closing that the law is on your side when you apply it to the facts, and then you can point to the jury instruction, that's incredibly powerful. People tend to respect judges, and if they hear a judge say, for example, that you have to follow the law and here's what the law is, and then you incorporate that law into your argument, well, that's certainly going to have incredibly persuasive power, and it's going to be very helpful. The final thing that I want to talk to you about with closing, and that's visual aids. Just a very simple, basic thing. People tend to remember more of what they see and hear as opposed to what they just hear. Now, this is incredibly difficult to do, and it takes a lot of work and advanced planning, but when done well, visual aids can make your closing so much more powerful. And every case offers an opportunity for a visual aid. It could be a blow up of the jury instructions. It could be a photo of a piece of evidence. It could be a chart that you put together showing inconsistencies in terms of a statement that was made by a witness beforehand and a statement that was made in trial. In other words, it should be your goal. You should strive in each and every case to use at least one visual aid during closing. Frankly, in my experience, a well put together visual aid is more powerful than anything that's coming out of the attorney's mouth. And when combined together with the effective delivery, the visual aid could be the thing that takes you over the top and helps you prevail and win. Now, some common questions that I get are first and foremost, how long should the closing argument be? And the answer is it should be short enough not to lose the attention of the jury. You have to read the room. When thinking about length, I want you to think about first and foremost, who are your jurors? Are they young, energetic people? Do they seem like they've been paying attention? Have they started to lose interest in the case? If you've been talking for a while and you notice that pens are being put down, people are looking away, they're starting to yawn, well, the reality is that you're losing them. It's not necessarily a reflection on you. The reality is that in this modern day and age, people's attention spans are quite limited as a result of, frankly, now almost a decade of social media and other machinery that have made it very difficult for people to pay attention. So, my advice to you is to read your room, pay attention to the jury, and once you can see that maybe you've made the point, there's nothing wrong with making something shorter, even though you intended for it to be longer. The other thing is to realize that you don't have to put everything into a closing. Hit the highlights, the most important points. Okay? Sometimes there's a tendency or temptation to think that you have to hit on each and everything that came out during a trial. And the reality is that you don't always have to do that. Just hit the important points. In other words, I know this is going to sound like a platitude, but you want to try to keep it and make it short and sweet. Now, a couple of other things to consider with regard to closing, and that's rebuttal. If you're the party that has the burden, you have the opportunity to go first and to go last. Understand that rebuttal is not going to be a repeat of your initial closing. It's only designed for you to bring up responses to new points that were made in your adversary's closing. If you don't have something to say in rebuttal, if you don't have something new and good, don't get up. There's nothing worse than wasting people's time by getting up and repeating an argument that you've already made. If people heard it once, they don't want to hear it again. For the individual who doesn't have the burden and doesn't have the benefit of rebuttal, you might want to think about anticipating the rebuttal and how you can incorporate arguments to that in your closing as well. So, closing arguments are incredibly tough, but I will tell you one final little piece of nugget information that I think has helped me throughout my career. All of the great closings that I've given came as a result of being able to pass this test. If it's a closing argument that my paralegal or legal assistant could understand and they thought was really good and it really helped them understand the case, then it was a good closing argument. The mistake that lawyers too often make is that we do these closings in front of other lawyers and we think, wow, they were impressed, they thought it was brilliant. And that's almost like, take this example. If people in Hollywood only previewed their films in front of fellow millionaires and billionaires, just imagine how flat a lot of movies would fall. Movies are focus grouped. People who do movies, they do market testing, they get polls, they try to figure out what types of things will apply to people outside of their bubble. And you need to do the same thing as a lawyer. If you are only running your closing arguments past other lawyers, you're doing yourself and your client a disservice. So, hopefully, these little tips helped you. If you're looking for a great book that tells you much more information about closing, I would recommend McElhaney's Trial Notebook. And last but not least, let me just say this. It doesn't matter what your style is. If you're a great energetic speaker or a quiet person, if you're an extrovert or an introvert, everyone can give a great closing argument. If you've ever once told a story in your life and you've made people laugh, you've made people cry, or you've persuaded people, then you have all the tools and the skills necessary to give a great closing argument. Good luck.